Hi, today I am going to share with you about the consideration of a court, the consideration of the court pertaining to the hostile witness. Now, what is a witness? What is a hostile witness? Witness is a person who gave information to the police during the process of investigation. Police collects the statements from all these witnesses and file a report in the court, which is called the charge sheet, after registering FIR. So now the witness speaks. Please note this point. Witness only speaks to the investigating officer. Witness never signs because he has witnessed the incident. That's it. Now the witness is called to the court during trial, summoned to the court during trial, and the witness speaks what he spoke to the police. The same or the different. It depends on the witness. His mind is refreshed by the prosecution by showing the statement, and after that the same statement is expected from the witness to be spoken in the court. He may speak the same whatever he spoke to the police, or he may resile from the stand that is taken with the prosecution. He may speak something else. In that case, the public prosecutor declares the witness as hostile. From the witness, from the category of witness, from the status of the witness, he will be called hostile witness. And when public prosecutor declares him as a hostile witness, public prosecutor will have the opportunity to cross-examine him. Otherwise, public prosecutor only examines him because he is the witness of the prosecution. The cross-examination is done by the defense. In this case, if he is declared as a hostile witness, the cross-examination is done by not only the prosecution, that is to say the public prosecutor, but even the defense witness. Even the defense advocate, the witness of the advocate of the accused. Now, when a witness is declared hostile, it is to the advantage of the accused. Obviously, he is speaking in favor of the accused and against the prosecution case. At those circumstances, how does the court consider? Supreme Court, in a recent judgment of Rava Sahib versus State of Karnataka, of course, it is an old principle reiterated in this judgment once again, that court will consider the corroborated part as admissible. Even though the witness is declared as hostile, the corroborated part and the non-corroborated part, there will be two parts in the statement of the witness. If the corroborated part, that is to say the part which was proved by other witnesses, the part which was proved by the circumstantial evidence, court will admit it and court will reject the uncorroborated part out of the testimony of the hostile witness. Now, I'll explain it with an example, you will be able to understand. Imagine two friends are going for a morning walk at 5 a.m. and one of them is hit by an enemy. And the person who was hit was in bleeding. He was hit with a rod of 2 feet length. He was immediately taken to the hospital. From there, he was taken to the police station and FIR was registered. Everything was done within a couple of hours from the incident, time of incident. So police investigated, they were walking in the park, police collected some witnesses, and the accused influenced the witness, the friend of the victim, who is a direct witness because he took the victim to the hospital, he gave information to the police, he obtained the wound certificate from the hospital, So he is a direct and the crucial witness to the case, but he got threatened by the accused. So during the process of trial, imagine he resiled from the statement that was given to the police. He might have said, suppose he might have said that the incident happened at evening 5 p.m. instead of morning 5 a.m. But he conceded the location of the incident. That is to say, he did not resile from the location of the incident. He did not resile from the time of the time when he was taken to the hospital. He did not resile from the time when he was taken to the police station for registration of the crime. All these were corroborated. All these incidents. The location was corroborated with the watchman of the park. The FIR was corroborated by the IO. The wound certificate given by the hospital was corroborated by the doctor. The presence of accused also was corroborated by the hostile witness. Imagine, all these situations are corroborations of the resiling the fundamental statement, resiling from the fundamental statement by the hostile witness. The hostile witness spoke that the incident happened at 5 p.m. not 5 a.m. The entire prosecution story has to fall based on that incident. But no, it doesn't happen like that. That part will be discarded by the court from the entire testimony of the hostile witness, because the remaining part of the testimony was corroborated, hence admissible. So therefore, if the witness becomes hostile, complainant need not worry. Still, if complainant could focus on the corroboration of the other witnesses, the hostile witness could not damage the case of the prosecution, is what I was going to share with you. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.